The location of this crime scene is very unique because it sits on a mountain. Part of it is shielded by a mountain. There's a lot of other big, thick, dense apartment buildings there. Your phone is going to behave differently inside of that residence than it might on the road behind the residence.
Bryan Kohberger, the accused quadruple killer. He may not be going on trial just yet, but that doesn't mean there haven't been some interesting updates as of late. That's what we're going to get into. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Hey everybody, this is a Law&Crime legal alert. Google Incognito tracked users' browsing data without their knowledge. Well, Mass Tort Alliance, one of our legal sponsors, is actually helping users file for compensation due to Google users' privacy issues surrounding Google Incognito. So if you've used Google Incognito anytime since 2016, you can start your claim in less than 10 questions at incognitoclaims.com/sidebar. With a lot of the other stories that we've been covering here on Sidebar, we haven't had a chance to talk about Bryan Kohberger in a minute. And there have been some very interesting developments in this case that we want to talk about. So that's what we're going to get into, the top 5 updates over the past several weeks or so in the Bryan Kohberger case to get you caught up to speed. So what are we talking about? We're talking about the former Washington State University grad student who was arrested and charged for a horrific quadruple murder that occurred on the night of November 13th, 2022. This is when 4 University of Idaho students were brutally stabbed to death in an off-campus rental home in Moscow, Idaho. Madison Mogan, Kaylee Gonsalves, Xana Kernodle, and Ethan Chapin. Kohberger was arrested 6 weeks after the killings. Police tied him to the murders through cell phone data, surveillance footage, and of course, DNA. Prosecutors saying the DNA on a knife sheath left behind at the crime scene is a statistical match to Bryan Kohberger. We're going to get into that a little bit more. But now let's talk about some developments as of late. And I'm going to start with a recent update. So the defense has been arguing that the prosecution hasn't provided them what they need for trial. They claim that the prosecution hasn't turned over to them all of this evidence like video footage and cell phone records. And we know that during the normal course of trial, there is discovery. In fact, in Idaho, the Idaho Rules of Criminal Procedure, Rule 16A, says that the prosecuting attorney must disclose to the defendant or defendant's counsel any material or information in the prosecuting attorney's possession or control, or the latter comes into the prosecuting attorney's possession or control that tends to negate the guilt of the accused. 16B adds to that by saying if the defendant makes a written request, the prosecutor has to turn over other evidence and material like reports, tests, documents, recordings, witnesses. There was a hearing. And during this hearing, Ann Taylor, counsel for Bryan Kohberger, tried to explain to the court how much of a problem this is.
I'll tell you the other thing that's really troubling and frustrating, aside from the other files that we received in preparation for motion to compel, is these screenshots that we got for the first time last week when we're on a motion to compel and have a witness before the court. We didn't have those screenshots that Detective Mowry had created before. The only thing we had was Exhibit 48 that was given to the grand jury, which is a video that was handed over then. So this is really problematic.
And at one point, to criticize the prosecution's discovery efforts, she said, quote, "Discovery is being given to us like we're living in a snow globe." Now, in fact, the defense, they called a couple of witnesses to illustrate that point as well. And I want to highlight one in particular, Cy Ray. This is a name you're going to want to remember. He's a very important defense witness that the defense plans to call regarding cell phone evidence. I'm going to get to him more in a little bit, but just listen to what Mr. Ray had to say about the evidence that the defense does not have access to.
I would expect significant drive testing around any location that coverage maps were being used in the CAS report. I would expect significant documentation on potential routes that this device may have taken. I would expect significant documentation on the crime scene.
And he went on to say, quote, "It is a terrible practice to justify probable cause with these very detailed call detail records that give breadcrumb-like trails for individuals and then not map it." And he also went on to say that what he has seen so far has been exculpatory for the defense, meaning tending to show Kohberger is not guilty. Quote, because of the piecemealing of the data, because of the missing data, because of the data I'm reviewing that is incredibly inaccurate, everything that is missing is absolutely in benefit of the defense right now. There are other reports that are missing that I can't tell you are benefiting of Mr. Kohberger or the state. And there was this back and forth between the prosecution and the defense on all this. And the prosecution, to highlight their point that they're doing the best they can, they even talked about how much they have turned over already.
To date, we've given 15,691 Bates-stamped pages of discovery. So for a little context, this is a 2-inch binder. It would be about 39 of these. We've given 13,758 Bates-stamped photographs. That's about 34 of those binders of photographs. We've given 911 AV dumps. Those are digital files. In addition to a massive hard drive, about 50 terabytes full of discovery. And that includes audio, video from about 285 interviews, 15,000 video clips from approximately 79 businesses, 8,000 video clips from approximately 10 residences, 417 files containing call detail records, multiple terabytes of records for 11 computer devices, 17 cell phones, multiple social media accounts, and 4 tower dumps.
Wow. And by the way, I cut that off. There's more that they described that was turned over, but clearly no wonder that this trial is taking forever and this whole pretrial process is taking a long time. Think about how much they got to go through. Also, by the way, big theme for the prosecution is we turned over a lot. And look, the FBI and the U.S. Attorney's Office, they haven't turned over to us what the defense is looking for. There's only so much we can do. We can't give over what we don't have. So as the judge sorts all that out, this now leads me to take a step back and talk to you about another major update in this case, the alibi. So for a long time, I would argue since Kohberger's arrest, we had wondered what would be his alibi. Where was he really during these killings, right? Now, we heard rumblings about what it might be, but it was more fully articulated back in April when Kohberger's defense team, they were given a deadline to submit an alibi defense. That's a requirement under Idaho law, and they filed just in time. So what's the alibi? Well, in their filing, it reads, quote, Mr. Kohberger moved to Pullman, Washington in June of 2022. As an avid runner and hiker, he explored many areas of the Palouse. Of note, he explored Wawawe Park in July of 2022, and this became a favorite location. After the school year began, Mr. Kohberger was busy with classes and work at Washington State University, and his running and hiking decreased but did not stop. Instead, his nighttime drives increased. This is supported by data from Mr. Kohberger's phone, showing him in the countryside late at night and or in the early morning on several occasions. The phone data includes numerous photographs taken on several different late evenings and early mornings, including in November, depicting the night sky. Mr. Kohberger was out driving in the early morning hours of November 13th, 2022, as he often did, to hike and run and or see the moon and stars. He drove throughout the area south of Pullman, Washington, west of Moscow, Idaho, including Wawawe Park. Mr. Kohberger intends to offer testimony of Cy Ray, CSLI expert. Cell tower, cell phone, and other radio frequency curricula vitae is attached to show that Bryan Kohberger's mobile device was south of Pullman, Washington, and west of Moscow, Idaho on November 13th, 2022. That Bryan Kohberger's mobile device did not travel east of the Moscow-Pullman highway in the early morning hours of November 13th, and thus could not be the vehicle captured on video along the Moscow-Pullman highway near Floyd's cannabis shop. Now, let me just quickly put into context why this is important. So in the probable cause affidavit from law enforcement, it states that on the night of the murders at 2:42 a.m., they say Kohberger's phone is connecting to a tower that covers his apartment in Pullman, Washington. 5 minutes later, the data shows that he leaves the residence and travels south through Pullman, Washington. This is consistent with the movement of the white Hyundai Elantra that was caught on surveillance tapes, the car they say he was driving. Then the phone stops responding to the network, and prosecutors say he shut off the phone purposely to avoid detection. Doesn't come back on the network until 4:48 a.m., 2 hours later, after when prosecutors say the killings happened, and then it hits the towers covering the area to a highway south of Moscow, Idaho. And then between 4:50 a.m. and 5:25 a.m., the phone hits a tower showing the phone is traveling towards Uniontown, Idaho, back to Pullman, Washington. 5:30 a.m., it hits the area providing coverage for his residence, and that is consistent with the phone being back at his residence, consistent with the movement of the Hyundai Elantra. When we cover stories like this about people who are either accused or convicted of committing crimes against people out of nowhere, people that you least expect, you got to ask yourself, how well do you know the people in your life? Do you know all you should really know? Well, that's why I want to talk to you about our incredible sponsor and partner who may be able to help you out here. This is TruthFinder. So TruthFinder is a service that can provide actual safety for you guys. And I say that because TruthFinder is one of the largest public records search services in the United States. Their whole goal is to help people like you learn about the people in their lives. And here's how it works. You go on their website, truthfinder.com, and you type in a name. And within minutes and a paid subscription purchase, you can access unlimited reports that can include information like phone numbers, location history, criminal and traffic records, including possible arrests, criminal convictions. Now, look, TruthFinder, I'll be honest with you, we have been partnering with them for a while now here at Law&Crime, and we actually use it to research some of the cases that we've been covering for you. But just generally speaking, TruthFinder can help provide peace of mind when you do these unlimited public record searches. Also, you know what's really useful? From within the report, you can search an address, like your home address, to see registered sex offenders that may live in that area too. That's the point. Unless you use TruthFinder, you may never know the reality about the people around you. And TruthFinder can be used to look up information about all different kinds of people you meet on social media, new potential dates, people you're buying or selling to online, the parents of your child's friend. Look, you can never be too careful. And right now, here's the kicker. You can get 50% off of your first month of confidential background reports. Just go to truthfinder.com/LC Sidebar. So, while the defense is suggesting that the prosecution's theory of travel is off, I got to tell you, I'm not sure at this point if they're going to either agree or disagree that Bryan Kohberger's phone was not connecting to the network during that key point in time. Are they saying when the phone was connecting, we believe it was in a different location than the prosecution is alleging? Okay. But what about when the killings were happening, right? That time period when prosecutors say that the phone was off. Are you saying we can really show where the phone was, that it wasn't turned off? Not just before or after the phone isn't connected to the network, but during that critical time of the murders, we'll tell you where the phone was? A little hard to say at this point. What we do know is that Cy Ray, who we heard from earlier, big witness for the defense, 20-year law enforcement veteran, worked over 1,000 death investigations, expert witness, testified in over 100 cases, including regarding cell phone analysis. So we're going to see. It seems also, I think the alibi is also trying to explain what he did before, or allegedly did before November 13th, 2022. Maybe they're trying to say, he was out and about, he was doing nothing bad, nothing nefarious, because remember, during the probable cause affidavit, it was revealed that Kohberger's phone GPS pinged at or near that house on King Road, the crime scene, at least 12 times before November 13th. Police say every one of those pings, except for one, happened late at night or in the early morning. And by the way, the cell phone data is consistent with the movement of the Hyundai Elantra. But it's interesting because prosecutors came out and said, we aren't arguing that he was stalking the victims beforehand. So it'll be interesting how all of this is argued at an ultimate trial. I will tell you that the car was spotted on several cameras passing the King Road home 4 times between 3:29 a.m. and 4:04 a.m. on the night of the killings, and then speeding away 16 minutes later. That's what the prosecutors are alleging. Then prosecutors say that car, they have it on tape, leaving the Washington State University campus at 2:44 a.m. They capture it heading towards Moscow. 5:25 a.m., the camera shows returning back to Washington State University. And by the way, later on in the afternoon, they track the phone to Albertson's grocery store, and they see Kohberger exit the white Hyundai Elantra. So they're matching him to the car. And not only that, after the killings, a Washington State University officer spotted a white Hyundai Elantra in the parking lot of an apartment complex near campus. The car came back, registered to Bryan Kohberger. So Kohberger and his father, they drove that 2015 white Hyundai Elantra from Washington to Pennsylvania in the weeks before his arrest. Kohberger, as you might recall, was pulled over by law enforcement twice on that trip for speeding and tailgating. Now let's talk about an update on DNA. So as I mentioned, this is a crucial piece of evidence in this case. Authorities took the DNA from the button snap of the knife sheath that was left at the crime scene, and they used genetic genealogy. They used a private lab to create a genetic genealogical profile. The FBI ran it through genetic genealogy websites, building a family tree, and eventually they compared it to DNA from trash that was recovered from Bryan Kohberger's family home. They concluded that there was a high probability that the DNA from the knife sheath is from the biological father. And so when they arrested Bryan Kohberger, eventually they do a cheek swap of him, and they found the DNA on the sheath is a statistical match to Bryan Kohberger. Prosecutors said in their filing, quote, the STR profile is at least 5.37 octillion times more likely to be seen if the defendant, is the source than if an unrelated individual randomly selected from the general population is the source. Meaning the profile that scientists developed is more likely to be Bryan Kohberger than someone random. Now, defense attorneys have been fighting back. More specifically, law enforcement's use, or IGG, investigative genetic genealogy. They have been saying that this has improperly led law enforcement to Bryan Kohberger. And the defense wants to understand exactly how Bryan Kohberger was targeted. The hope is that they could say this was all improperly used to target him, to name him as a suspect. Their argument would be that this is unconstitutional, that it violates the Fourth Amendment against search and seizures without probable cause. Prosecutors have said that IGG was not used to obtain any warrants in this case, that this was a tool that was used, but it was not the end-all, be-all to arrest Bryan Kohberger. This was more based on good old-fashioned police work. But this is where it's interesting. So reporting indicates that the defense has two witnesses that they had wanted to testify in a pretrial hearing, and it seems possibly they want them to testify in an upcoming trial. Leah Larkin and Bicca Barlow. So our research indicates that Leah Larkin, PhD, is a genealogist who has criticized IGG in the past. In a filing from last year, she talked about genetic genealogy, how it's been wrong in the past, how law enforcement improperly utilized these services, especially when she claims that certain sites like 23andMe prohibit IGG. She says genetic genealogy is not perfect. In one of the filings, she's quoted as saying, any given centimorgan amount can represent more than one possible relationship. Bicca Barlow is an attorney and forensic consultant who specializes in forensics, DNA, criminal cases, including STR-based DNA testing, mitochondrial DNA testing, and YSTR-based testing. So as of a recent hearing, there has been a battle of having defense experts, presumably Barlow and Larkin, review IGG materials and unseal certain portions of this. And earlier this year, the judge did order the prosecution to turn over some of these IGG materials to the defense. It makes sense because they want to attack this, arguably, again, one of the strongest, most direct pieces of evidence against Bryan Kohberger. So that will be an ongoing battle. Now I want to focus on another update in the case, the victims' families. So as you can imagine, as all of this legal maneuvering is going on, this can't be easy for the families. In a recent statement from the Gonsalves family, it reads, quote, this case is turning into a hamster wheel of motions, hearings, and delayed decisions. Can we all just agree that this case needs to move forward and the judge needs to start setting hard deadlines in this case? It goes on, not every motion needs a hearing. Not every decision needs to take a month to decide. Discovery, discovery, discovery. You have what we want. No, I don't. Yes, you do. No, I don't. Let's have a new hearing. Hit repeat. This banter has been going on for 17 months. Then once you get a hearing, you have a hearing about the decision that was made at that hearing before the last hearing, and there needs to be another hearing. I know our statement sounds as if we are incredibly frustrated, and we are. We understand the justice system, and we want a fair trial for the defendant, but turning the case into a delay game serves no one's interest other than the defense. Once again, thank you all for your kindness and prayers for our family. Now, That is completely understandable, especially since there's a possibility this trial may not happen till spring or summer 2025, almost 3 years after the killings. His family deserves finality. I get it. It's completely understandable. Now, as they mentioned, and I'll highlight this from a legal point of view, it is important that a defendant's rights are protected and that they are given every opportunity to present a defense, because for the families who believe Kohberger is the killer, the last thing they would want is for him to be convicted and then the conviction overturned on appeal because some mistake was made during the pretrial process. That would prolong this. That would prolong the pain. Also, what must be incredibly frustrating for the family, and I'll tell you, the public and the media too, was the decision to close hearings in this case. That's another update, because listen to this back and forth between the defense, the prosecution, and then Judge John Judge on all of this.
Both contemplate balancing this public right to an open hearing versus the interests such as privacy, safety, and the right to a public trial or to a fair trial. In deciding whether or not to file the motion to close the hearing, the state weighed those interests and ultimately came down that the need to protect the privacy and the sensitive information and ultimately protect the state and defendant's right to a fair trial outweighs the right to an open hearing.
For the court to allow the prosecutor to say, we need to keep this all private for a fair trial, really ignores the public nature of this case. It really ignores the fact that Bryan has been essentially convicted in the media. You don't have to read but a few articles to see how negative they are about him. He has a right to have this information withheld, brought out in public, so that people can see it's not this neat little package. So people can start to wonder if Bryan's innocent. Your Honor, Bryan is innocent. And he has an absolute Sixth Amendment right to have his hearings in public.
All right, well, I kind of mentioned this a moment ago. I just feel like we need to get into the details, okay, of all these issues before I open it up. So I'm gonna close that hearing. Now, that doesn't mean that after we sort out all of those issues and I have more understanding of why you aren't getting what you want or what you asked for, or whether or not there is something that you've asked for that doesn't exist, or that some of the materials are holding with the FBI, and that we need to get that. I mean, those are all really complicated processes. And I would feel much more comfortable when, again, I'm trying to protect a fair public trial and not have a maybe not intentional unfair hearing, okay, that goes out to the public. I think that's the balance for me. That I want to see what all the issues are, the arguments from both sides, so that I can make a more informed decision.
So yes, hearings have been closed in this case. There is a gag order in place that makes understanding what is really going on a bit difficult. The judge is going to have to try to streamline discovery in this case to keep things ongoing. And then, of course, there's the idea of when this trial will actually happen and where it is going to be held. Our final update, June 27th, the judge is seemingly going to decide whether to move this trial to a different venue. Prosecution says the trial should happen here, should be heard by this community. Defense has argued that Bryan Kohberger cannot get a fair trial here. They have been supporting that with phone surveys of potential jurors, which, by the way, created its own headache. The prosecution said that these surveys were problematic because potential jurors were being asked very specific things about the case. Kohberger's arrest, the car, the DNA, the knife sheath. And they were saying that this is potentially tainting a jury pool, that this is prejudicing them. The judge said, look, these surveys can continue as long as the questions stick with things that are in the public record, which a lot of this already is. You just can't violate his gag order. So those are some recent updates. We are going to do our best to continue following what happens next, including where this trial is going to happen. That's all we have for you here on Sidebar. Everybody, thank you so much for joining us. As always, please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. Speak to you next time.